All right. Hello, hello, attendees. Looks like we got people trickling in at this point in time. I appreciate you guys joining. And for today's agenda, we're going to be going through brief introductions. We're going to talk about 2 years into civil remedies, safe harbor security requirements, and what HB 1423 could change, followed by Q&A to wrap things up. All right. So let's jump into introductions. We have Amanda Potlucky. Now, Amanda is no stranger to our webinar. She is one of Florida's most sought after liability attorneys in property management with a client list that includes Greystar, RPM Living, and many more. Now, Amanda is one of the ones who told us about the tort reform in 2024, and she's equally clear about the risk and where they live.
Hello, I'm so happy to be here. Excited to talk about this. I know we're a few years in, but there's still a lot of questions that everyone has about the issue. So hopefully between Randy and I, we can get some of those answered for you today.
Yes, definitely. Thanks for joining us again. All right. Next up, we got Randy Atlas. Randy, now America's only architect and criminologist, a leading Florida CPTED practitioner, author, and expert witness. Randy conducts risk assessments, security vulnerability assessments, and his CPTED studies for public and private sector clients. He's also CAP B class certified in the International CPTED Association. So, Randy, thank you for joining us.
Hi, thank you. Thank you so much for joining us in this discussion about this controversial bill that was passed by the legislature a couple years ago. And our intent in today's discussion is to help provide clarity where there are still a lot of clouds and confusion about how to apply this and whether to assume the risk or actually bite the bullet and get this done so that you are well protected.
Most definitely. Well, thank you guys both for joining. And myself, I'm Joseph Turner. I'm the National Account Executive with Clouded Structure, and I'll just be running the webinar. So we'll jump in. I believe we got some questions for the poll. You know, I myself always like jumping into the webinar with some numbers and throwing some stats at you. So why tort reform changed everything for multifamily? So, you know, as mentioned, this is something that was kind of implemented a couple of years ago. And before, we were looking at 1% fault owner equaling full lawsuit. So, you know, you could have 1% owner fault and you're pretty much entitled to that lawsuit. So completely changed the game. Now it's more 50% plaintiff fault equals no recovery. So, you know, there's a lot of loops and bounds and policies in place now to help protect you and your property. And I mean, some of these statistics on this page are pretty staggering. You got 76% of U.S. insurance litigation coming from one state, with the state just 8% of those claims. I mean, lawsuits filed, you're looking at 70,000 plus lawsuits filed in just 6 days before the statute was signed. And one firm alone filed 25,000. So just some real staggering numbers there. I mean, before the nuclear verdicts, Florida was ranked number 2 with nuclear verdicts. And, you know, that scaled back down to, 8 spots, back down to 10, in 2024. So just some crazy statistics and some numbers out there surrounding this reform. Randy, I'm going to have you kick it off and just really compliance requirements. Walk through the 11 CPTED measures required for substantial compliance.
Yes, thank you, JT. First of all, that these surveys can only be conducted by someone who's gone through the Florida Attorney General's CPTED course, and or if you are a certified law enforcement professional, i.e. a police officer. Although it's been my experience that no police officer wants to touch this with a 10-foot pole because of the liability that if they do these surveys and something happens, they're liable or could get drawn into a lawsuit. So the departments are discouraging participation in doing these assessments almost universally. Secondly, the law calls for video surveillance coverage at the entry and exit points of the property. It's unclear where you have exceptions to that rule, where you have 2 doors or whether you have townhouses, but being a subject matter expert in the field of CPTED and having gone to different workshops with the Florida Crime Prevention Organization, as well as the Design Out Crime in Florida, where the Florida AG's office is there. Their intent is that where you're coming into the property needs to be under video surveillance and or license plate reader. And if you have a single point of entry going into, let's say, a mid-rise or high-rise building, you'll have video surveillance there. If you have a typical two-story townhouse development, you do not have to have cameras at every single door entrance. Video storage for 30 days, obviously to be able to recover that data for the law enforcement to determine video evidence for prosecution. Specific lighting levels in parking lots from dusk to dawn. And that's a subject unto itself, but I'll just give a summary saying that the lighting levels required for parking lots are 1.8 foot candles at 18 inches above the ground, which is not a national standard of care. It's not part of the Illumination Engineering Society security guidelines. It's a number that was pulled out of some legislative aide's ear, and we're just having to, deal with that. And that means that every single parking space has to be measured and that the minimum average has to be greater than 1.8 foot candles. On the other hand, if your property has a parking garage, easy breezy, simple. You use the Illumination Engineering Society safety standards, and you can take periodic measurements, and you're looking at probably 3 to 5 foot candles. Lighting in common areas, walkways, and laundry rooms. Again, the intention here is to have a minimum level of lighting. They do not specify the lighting level, which now would then kick it into Florida Building Code, local zoning ordinances and regulations, and or national industry standards such as the Illumination Engineering Society, and what they suggest for those, for example, like mailbox areas should be 10 foot candles. A larger room, probably 5 foot candles. Most zoning codes require 1 foot candle for exterior sidewalks. A 1-inch throw deadbolt lock in every exterior door. What they don't, that's the good news, that they don't specify is the screws that hold the locks and the strike plate into the doors. And there's some industry standards and best practices of what to do there. Locks on windows and sliding glass doors. Again, the ability of latching and securing windows and doors, which is the primary means for burglary and illegal entry into a property. What they don't specify in this law is having ventilation locks so that on a nice day of weather, which we're not having right now, it's very hot, and come spring or fall, it's a nice day outside, you can open up your door or window 4 inches and there's a lock so that someone can't just slide the door or window open and break into your apartment. Access control locks on pool gates. This new law requires either a PIN code, a key, biometrics, an RFID card. What is not acceptable anymore is what is in the Florida Building Code and what we've known for the last 3 or 4 decades, which is that 48-inch pole that you just pull the tab up and lets you in. Apparently that just has been not secure enough to prevent children from coming in and drowning or trespassers. Peepholes on doors without adjacent windows. Again, if you have a side view panel or you have a window in the door itself, you don't need a peephole. But if you do have a peephole, then it needs to be at the proper height so that inside the person can see who is knocking on the door. CPTED surveys every 3 years, so they want this survey to be reconducted or reevaluated every 3 years. And there's also a training component that they want the management staff to have a brief overview of the state law and what is CPTED and what is their survey results find so that they can make sure the doors latch and that the lights are on and that you don't have loitering and trespassing and open drug dealing and other problems on your property. JT?
No, that's great. And, some questions that are popping up, for, us who haven't heard the term, what is CPTED design? What does that entail? And why does it matter for compliance?
CPTED, or Crime Prevention Through Environmental Design, is when you design security into the built environment to reduce the opportunity and fear of crime, and as a result, improve the quality of life of where you live, work, or play. And this is done by improving the ability for natural surveillance, like through windows, or mechanical surveillance with cameras, or operational surveillance with like guards, and also access control, again, natural access control, mechanical access control with locks and hardware, and organizational access control with like a security guard, doorman, concierge, and territoriality or boundary definition, the perimeter fencing that defines what is your real estate versus the general public real estate or other people's real estate or state-owned real estate. So these are the elements that are designed into the building that can improve the ability and the likelihood for success in reducing the opportunity for crime.
Okay. Now, is the CPTED analysis different from, the 7 required items and say presumption against security negligence, or
Yeah.
is it the same thing?
No, it's not the same thing. All the items in the 7 required items that comes in the beginning part of the state law are mostly physical hardware and lighting issues. Then the law calls out separately to have a separate CPTED analysis of the property, and that's going to cover all of the other items such as signage and landscaping and planting and maintenance and graffiti and tagging and trespassing on the property, and are things in working order. So the seven items that we've just discussed about video surveillance at entry points, deadbolt locks, peepholes, locks on windows and doors, the pool lock, lighting in the common area spaces, lighting in your parking lot. Those are all the things that are part of the 7 you must have substantial
Right.
compliance or substantial implementation of. The CPTED
Okay.
part then looks at the global, the bigger picture of what's happening in that property. Are you having good management practices? Are you screening the tenants? Are you making sure that the door maintenance is proper? Having the proper strike plate screws would fall under more of a CPTED recommendation rather than it goes beyond just having the 1-inch deadbolt. How do you secure the deadbolt and the strike plates into the doors and the door frame? So that the CPTED covers all the other unfinished business.
Okay. Now, does a site inspection have to cover every apartment unit and every building, especially with those garden style communities and the surveillance surrounding that? Does it have to be at every entry? Because I mean, that could be pretty large. Does it need to be in more like targeted areas or that type of approach? Or how does that work?
JT, that's a great question. The answer to the way the law is written, it would suggest that every single apartment or condominium has to be looked at. On the other hand, that is just unreasonable expectation that you're going to be paying a security consultant's hourly rate to be literally going into every single apartment. How Atlas Safety and Security Design handles that is I send out a survey form that requires the management and maintenance staff to go out and physically check every single apartment for the door lock, for the window lock, for the peephole, for the glass door lock, for lighting levels and things of that nature. And I have them notarize it in blood that they will attest to the fact that someone actually had visual thing, because when I go out in the field, I'm doing a random sample of if it's in a townhouse development, I'm looking at one unit at each one of the buildings. Not every apartment in the building, but at least a random sample on each floor or a random sample on each building. Again,
Okay.
as I walk around, if I'm finding doors that are not properly secured and the peephole has been painted over and the deadbolt screws have been, are loose and, the lock is jiggling and there's no window locks or sliding glass door locks, I get real ugly with management because you've just signed a legal document attesting the fact that they're all in compliance. So I read the Riot Act to management that if you cut and paste that everything's in compliance and I find that it's not, I will go out into every single apartment and bill you accordingly, and you will be very, very, very sorry and poor. So the
No.
answer, so the bottom line is yes, because the one apartment that has not been checked, where there's not a
Right.
window lock or the window lock has been removed or the screws have come undone, and that's the one apartment where a child falls out of and
Yeah.
falls to their death, you're going to be liable because you're attesting the fact that every single apartment in that facility or property is compliant, substantially compliant, or implemented the 7 features and the CPTED analysis.
Now, I know we need to move on to the next slide, but real quickly, which staff members need to be trained with CPTED? And I mean, which ones need to be trained with presumption against security negligence? Is that everyone? Is that, how does that all work?
Great question. So what I've been doing is I've just built a little PowerPoint presentation online, and I present the manager of that particular property, and I ask that it's 90 minutes. And most of the other people doing the surveys, they offer an hour to a 2 hour worth of training. And as a result, I want maintenance to take it. I want the management in the office, the real estate office, where they're signing up new leases, to take it. If there's a security guard company, I want them to take it. So what I'm finding is the more participation you get from people in the security process, in the CPTED process, extends your eyes and ears on the property. And it complements what you do in cloud structure as far as providing a remote mobile guard service. So yes, the training, it's to the advantage. It's free. It's available out there. If people take it, they get a certificate of compliance. And again, all of this is about leaving a paper trail. So when they contact Amanda saying, I need help, defend me, you've got the strong paper trail of a certificate of compliance for the property, and that your staff have been trained. Here's your certificate of training. And now go ahead, knock yourself out in court.
Great, great. No, that's super helpful. Now let's shift over to Amanda. Next slide is you. What does the presumption actually do? What substantial implementation mean, and what courts are likely to do, and what are they likely to look for?
Sure. So that's a good question, and one we're still trying to figure out here in Florida 3 years in. But first, I want to take a step back. Even before this presumption, there were a couple of other really interesting changes that affect negligent security claims across the board. So not just with multifamily properties, but in general in Florida, the tort reform also brought us the ability to apportion fault to a tortfeasor. So if someone comes on the property, commits a crime, commits an assault, a robbery, burglary, whatever the case is, that person historically in Florida prior to 2023 couldn't be on the verdict form. So that was kind of a rarity. Most states did allow that. So we now have the ability to apportion fault from a liability standpoint onto the actual tortfeasor, the intentional tortfeasor. So that is one step, the kind of the first step that helps reduce the risk of liability in these negligent security claims. And that's, again, across the board. It applies to commercial properties, real properties of all kind. And then we have this specific topic, this presumption against negligent security. And this specific portion of the tort reform and the statutes actually apply only to multifamily properties, and it actually applies to both, to condos, townhomes, all types of multifamily properties, but also to both the owner and the operator. So the owner and the property manager. And we know everyone who deals with this type of litigation in Florida, we see everything across the board. Some plaintiffs' attorneys, when they file suit, they name only the property owner. Sometimes they name only the property manager. Sometimes they name both. So it protects both entities from negligent security claims with this presumption. And the word presumption, is just that. It's not a complete defense. It's not, here we go, we complied, game over, summary judgment in your face. It's just a presumption. And so that means that if these multifamily properties, the owners and the operators, can establish substantial implementation, and that's kind of the key phrase here, the trick, the words that we have to focus on, substantial implementation, because that's all the guidance we were given by the statute. And I know Randy already mentioned, that it wasn't written quite as well as we would like, and I think that's putting it nicely, but that's all we have to work with. So when we look at the statute and we look at this list, it's actually, I know here it's listed as a number of bullet points, but the way the statute is actually phrased is you have these first, the first several bullet points from on the screen, from assessor being a CPTED certified, all the way down to the peepholes, those, as you refer to, the hardware type of implementation, and the lighting and the security and things like that. That is one section of it. And then you have the CPTED assessment, and then you have the education and training of the staff. And so the way it's set out is it's required that there's substantial implementation. So in the event of a claim or a lawsuit, it would be on the property owner or the operator, whoever's named, to come forward with proof, with evidence of substantial implementation. And once you have that, then we've established a presumption against liability, and the burden then shifts to the plaintiff or the claimant to then try to prove negligence in spite of that presumption. So it is a very high threshold for them to do that. Once we've established that implementation, which again, we don't really have a lot of guidance on. So when we're looking at, well, what is substantial implementation? We have to take into account not only the number of factors that have been complied with on this bulleted list, but we also have to then consider the substantive aspect of the implementation. So for example, if you had a drowning or something related to the pool, that one element regarding to the pool locks, the access control to the pool, would probably be the most compliant. So if you complied with everything else but you didn't have that, it probably wouldn't be considered substantial implementation, even if you hit the other 8 out of 9 topics, but you didn't have the one that really mattered in that claim. So it's kind of a numerical compliance as well as the substantive compliance based on each specific claim, and making sure that you're tailoring compliance to the issue at hand. So I know that was kind of a long answer to your question, but it's really just there's so much up in the air that the more you can do to implement all of these things, the better chance you're going to have in being able to shift the burden back to the plaintiff or the claimant and establish that substantial implementation.
That is very helpful, very helpful. Can you break down what the shift from, say, pure to modified comparative negligence actually means for an owner facing a lawsuit? I know Kathleen is putting in the chat our interactive map right now, but can you kind of break that down?
Sure. So before 2023, when the tort reform laws were implemented, Florida followed what's called pure comparative negligence, meaning that if someone came on your property and they were injured, or if there was a resident, guest, delivery person, whatever the case is, if they were mostly at fault, they could be 99% at fault and still recover that 1% from the property. So it resulted in a lot of litigation and a lot of verdicts with, potentially, significant litigation, significant cost, significant time poured into it, and then they can still recover that 1%. Now we've shifted to this modified comparative negligence, which basically means that anytime the plaintiff themselves is found to be more than 50% at fault, so not 50, it has to be more than 50, then they are completely barred from recovery. If it's 50 or less, then it still goes back to that proportional comparative standard. So if you were to go to trial and the plaintiff were to be found 49 or 50%, they could still recover the other 50 or 51%. If they're 51% at fault, they would get nothing regardless of the rest of the verdict and the rest of the decision from the jury. So it's helped reduce verdicts in the cases where the plaintiffs themselves are comparatively at fault.
Now I'm looking at this slide and I see, one thing that pops out is that statute of limitation, 4 years to 2. What significance does that have? Is that making any differences?
That's very significant in terms of investigation and preservation, especially in Florida. I mean, we obviously multifamily properties face different challenges, but we also have a lot of hospitality litigation here too. But between the hospitality and the multifamily litigation, that is so much of our litigation in Florida that, having a 2-year turnaround time really helps move these claims forward, but also facilitates the investigation part of it. It reduces the elimination of evidence, because obviously after 4 years, people move, evidence changes, things are lost. So keeping that, reverting back to the 2-year statute of limitations, which is consistent with a lot of other jurisdictions, helps really, on the defense side at least, it really helps the ability to investigate and preserve evidence and really, be able to get in early, especially when you have something so critical like video evidence that can be preserved and that can be downloaded and saved. That statute of limitations is really significant, and it just prevents, claimant attorneys from dragging out the pre-suit phase of these claims for such a long time.
Now, regarding the assessments, do they need to go through the properties association, legal counsel, or how does that need to be handled?
I think Randy wanted to weigh in on this one.
I will address it from a practitioner's implementation perspective, and I'm hoping Amanda will put a legal spin of what is best practice or industry standards. I suggest strongly that even though you don't have really protection of this report from prying eyes of a lawsuit, because the first question I'm going to ask if I'm an expert on this case is, did you conduct the required House Bill 837 study? And if I get an answer yes, then the next question will be, great, produce it. And then the attorneys will force the property management company or their HOA to produce it. I suggest that it goes through the attorneys of that homeowners association or that property management company or the owners, so that there's at least a little bit of a buffer of protection of whether it's just public information or you have to have it essentially subpoenaed, and you demand it as far as discovery from a lawsuit. So I think it's very helpful. There's nothing in the law that requires it. It's unclear, even though it's, anytime I've ever done a risk assessment for a commercial property or a residential property, the first question I ask is, would you like it to go through legal counsel so you have some buffer of protection? And sometimes the answer is yes, or sometimes no, but my job as the assessor is to ask the magic words, ask the question. Amanda, do you think it's wise for these reports to be going through legal counsel?
I don't necessarily know that it matters entirely. I mean, I think as far as going through legal counsel is always beneficial because there might be protections in place that counsel is going to have knowledge of. But as far as once the claim is in suit, once the lawsuit is filed, these are generally going to become discoverable anyway, particularly if it's a negligent security claim and the property is pushing the presumption. Obviously, if we have this on file and it's presumably favorable because we've gone through the steps and the property's gone through the steps to make sure they've complied and that the CPTED assessment is done and it's done by a properly certified individual, then that's something that we're going to want to use in creating that presumption. So, and obviously the first time you take a deposition of a corporate representative or an expert or whoever the case is for the defense, that's going to be one of the first questions you're getting from the plaintiff, and probably even in written discovery, is do you have the CPTED certification? Do you have the assessment? When was it last done? And sometimes it's not even a specific CPTED. They'll just say, have you ever had a security assessment done in the last 3 years? If so, produce it. And again, if it's favorable and it's something that we're going to want to use to establish that presumption, it's something that we're going to want to turn over. But I think as far as before you get to that point, before you have the discovery issue, then going through legal counsel, yes, is always preferred.
Okay. You mentioned like exclusions against liability for trespassers. I mean, that's pretty heavy. Can you tell us a little bit more about that one particular?
Sure. So Florida generally protects invitees on your property. So again, with multifamily property, it's going to be your guests, your residents, and then you do have the kind of not really a gray area, but you do have a lot of delivery persons, especially as Uber Eats and DoorDash and all these delivery services, Instacart are getting so popular and people are using them so frequently. You have a lot of delivery individuals on your property as well, and those are essentially treated the same as an invitee, presuming they're coming to deliver to the resident within authorization. So when you look at all these people that are on the property legitimately, that's where your presumption is going to come in that we've already talked about. That's where the standard negligence principles are going to apply, and that would be your traditional claim. But there's another set of individuals, and those are trespassers. So if you have trespassers on your property, there are specific exclusions, and the duty to those individuals is not quite as high because they're not supposed to be there. So there's generally an immunity from liability for trespassers in a number of situations, and the statute is very detailed on the nature of these trespassers, but generally speaking, when you have a trespasser on the property, the duty is lower and there's often a immunity from liability. So if you're able to identify the person on the property who is a trespasser, say they come on the property to commit a crime, they're in the parking lot to commit robberies or theft of vehicles, and they get injured, well, obviously there's going to be a certain protection from liability versus somebody who's there legitimately. So being able to identify these individuals, why they're on the property, how they gained access to the property is really critical in that first analysis when you're analyzing these claims to decide what the duty is and what the threshold issues are. If you can determine through surveillance footage or camera footage or whatever the case is that they're not supposed to be there or they didn't lawfully gain access to the premises, then you have a defense right out of the gate that you might not realize otherwise if you don't have that information.
That's exactly why I would say active, or you're just documenting, monitoring really, really matters, and being proactive in that stance. Now, to both of you guys, I'm hearing that even though the courts haven't ruled yet, insurers are expecting compliancy. What are you guys seeing from both sides?
I'll put my 2 cents in first, and it's probably a different experience than what Amanda has. It would have been great had this law been written with one of the participants being the insurance commissioner of the state of Florida. Why? Because if your property does conduct this exhaustive and expensive survey, and you get a certificate of compliance, and you train your staff, you know what? You get a 10% discount on your property insurance. Now, we all, and I say that collectively, we, if any of you've gone to a high school and you've taken a driver's ed course, you get a certificate, and you bring that, give that to your mom or dad, and they turn it into the insurance company, and you know what? You get a discount for you being a safe driver because you took the safe driving driver's ed course. This, if property owners were getting even just a 5 or 10% discount on their property, the required liability insurance, and this could amount to saving hundreds of thousands of dollars, you would see a rush to have this compliant. But because, again, the legislators sought out no subject matter expertise in this at all, even from their own Attorney General's office, this is a huge lost opportunity. And even though I've suggested it to the powers that be, I was basically told that there was zero possibility of having this law fixing the glitches, because once they open it up for tweaks, then in fact, the Morgan & Morgans of the world are going to come in there and just water it down to the point of where the law has no teeth at all. So at the end of the day, what's the highest good? I think that there needs to be an effort to present this to your insurance company, that you're complying, and maybe they'll give you a discount, a safe living, a safe driver discount. But at the very least, I think it helps you from a legal position that your insurance rates won't go up if in fact you were complying with state law, as compared to just assuming the risk.
Amanda, you on that?
Yeah, I mean, I think this one's tricky just from a practical standpoint. I think what Randy's saying makes logical sense, and we would all love discounts. I think who wouldn't, especially if you live in Florida, you're familiar with Florida. Anybody wants a discount on any insurance rate, tax rate that we can possibly get. So that would be great. I think the problem with this is that because the statute is so vague and because tort reform is still such a giant gray area, there's still just so much litigation. And with litigation in the Morgan & Morgans of the world coming in and continuing to file these lawsuits despite the tort reform statutes, despite the presumptions. And to be honest, there's just not a lot of pushback yet, without the assistance of the courts really helping us on the defense side with that pushback. It's not really cutting down on that litigation. So I think the hope is that in the future, as the presumptions and as the implementation is better defined and we can push back, then it's going to reduce, hopefully, the amount of the negligent security litigation and reduce the number of claims. That's probably wishful thinking because Morgan & Morgan's going to find a way wherever there's a way. But I think, there is where, the kind of the greater good, everybody benefits if we can cut down on that litigation, or they might be less inclined to file suit in a negligent security case in a property that they realize probably has substantial implementation of these security features. So, I think it's wishful thinking to, ask for a safe driver discount, and that would be great. But I think until the insurance companies actually see the verdicts going down and the litigation decreasing, it's going to be hard pressed for them to actually offer that discount when they're still facing such high costs.
I know that's always the big question when it comes to insurance within the multifamily world. Now, for both of you guys, I mean, would you recommend Florida property managers start pursuing the compliance certifications right now? Randy, you go first, and then, have Amanda follow up on that.
I believe Dirty Harry phrased it correctly when he said, "So, are you feeling lucky today? Are you feeling lucky, punk?" No. If you're feeling lucky and you want to assume the risk, okay, then just, don't do your survey, don't fix the lighting, don't trim the bushes, don't implement proper screening methodologies for your tenants. Don't keep the maintenance people, accountable for keeping the lights on, the wheel curbs anchored to the ground. And then when you get hit with a lawsuit, you are naked before the king or the judge. My feeling is that proactive measures not only will save you money in potential lawsuits, but how I try to sell this is it increases market value for your property. We live in times that are out of control on so many different levels, and with the level of incivilities and social behaviors being just what they are, which is the kindest way I can say that, my position is if it's going to, one potential lawsuit that this helps get you out of or get your case dismissed with a summary judgment is worth the fee for the surveyor, fee for the staff, fee for all the attorneys, it's a win-win situation. And someone wrote a question earlier about, well, what if the number of crimes go down? If crimes go down, it doesn't necessarily mean that you've lost your need to maintain security presence, cameras, lighting, maybe a roving patrol. Once you've established that you have that as a requirement, it's really hard to say, well, I just worked on a case in a garage in Wisconsin where, oh, crime went down after the gang got arrested. Well, that's just not the case. Now that you've had someone assaulted and raped, how do you in fact say that you don't have the need for maintaining that roving patrol and the cameras and the signage and the ground floor protection? So bottom line is, proactive approach is much better than a reactive approach, because the only ones who profit are the attorneys, and the property owners and managers always lose.
Yeah, without a doubt. Amanda, your thoughts on that?
Yeah, so I mean, I think within reason, to the extent that it's reasonable and cost effective to be able to implement these things ahead of time before there's a lawsuit, before there's a crime, obviously it benefits everybody. If it's an older property and some of those physical components cannot be complied with, it might just not be feasible to add that to a property after the fact. But something like lighting or the security cameras, those things that are easily added regardless of the age of the property, regardless of the size of the property. So to the extent, within reason and it's cost effective and cost efficient and feasible to add these things and to do the CPTED assessment and to train your employees on the training that is required, it doesn't hurt. You're never going to be punished in a lawsuit for having too much compliance or too much security. You can only be punished or penalized. It can only harm you if you don't comply. So to try and bring your property up, to comply with that substantial implementation requirement, while you can, obviously it's beneficial for the residents and the employees on site anyway to just have those security measures. But from a liability standpoint, it certainly helps to make sure that you're ready in case there is an incident. Of course, you can't prevent crime from happening. Some things are just unforeseeable. And, that's the other thing is Florida, law doesn't hold properties to perfection. There's not a strict liability issue here where if there's a shooting or an assault or some type of incident that you're automatically liable because you own the property. There's still a negligence aspect. There's still a foreseeability analysis that is done on the property. This presumption just helps raise the bar so high that it's going to be very difficult for them to get over that hurdle to make their case. And that's why the substantial implementation, while you have the chance to do so, is just going to benefit you in the long run and certainly cut down on litigation costs if you're able to meet that presumption before you get all the way to a costly trial.
And you kind of alluded to it earlier when you said, when I asked about the list and compliancy, just having as many of those items checked off is going to benefit you. So Absolutely. That kind of absolutely covers that as well. Now, there looks like there's a question in the chat. This one I think is going to go to Randy. Question is if there are any stats on how many properties are actually in compliance as of right now. Is there anything that really speaks to that currently?
A good question. When they set up this law, there was no clearinghouse set up to track the data, which you'd want to do, like on drug overdose or car accidents or burglaries or graffiti attacks on your fences or whatever it might be. So we know that there's over 1 million apartment properties in the state of Florida. And I would say, based on the request of myself and some of the other firms I know, we're hitting like 0.001% of the properties are even inquiring for a proposal. And of them, 10% actually say, okay, I'm willing to shut up and pay and actually move forward with this. What I am finding is it is the larger property management companies that are just, that usually get clobbered in court and having to pay multi-million-dollar settlements that are saying, you know what, for the cost of one settlement, I can get all my properties surveyed and then some, and then basically get my certificate and have my paper trails. I can have my day in court and tell you to pound sand. So I think that there's very, very few properties that are actually moving forward. The larger property management companies are realizing the value in doing this and really, in the long run, saving money, not if, but when they end up in court. The small mom and pop properties are just saying, no, I'm not paying for someone to come out there and tell me what I already know, which is I don't have good lighting and I don't have fencing and I don't have good door lock systems. And my tenants are basically on the post office wanted list.
Yeah. Now, Amanda, With your clients, I mean, you got a pretty large portfolio of clients. Are you noticing a high number of properties falling in line and that are complying, or what are you
Yeah,
seeing on your side?
I think with that first list, when we looked at back at when we think back to that bulleted list, and we had the kind of 7 or 8 physical requirements, the door locks and the windows and the lighting and things like that, the security cameras, those
Those
are
factors.
more typical as far as compliance. I think the CPTED assessment is the one thing that I'm not seeing as much on properties across the board, and I think it's just because honestly, I don't think it's a lack of compliance or conscious effort not to do it so much as people just still don't really understand what it is, maybe, or why it's important. So I think the CPTED assessment is probably one area where there could be some improvement. But I think those physical requirements or the physical implementation portion of the statute is a
Mhm.
lot, more common as far as compliance in the CPTED assessment.
Makes sense. Now, there's also a question in QA asking if the law affects hospitality. Amanda, or I
Yeah,
mean, both of you guys, honestly.
so as far as this presumption was only written for multifamily housing. They made a conscious effort when they wrote these statutes and when they passed the tort reform laws that the presumption against liability in negligent security cases, what we've been talking about here, the assessment, these physical requirements, that presumption is only limited to multifamily housing. For typical hospitality, hotel, restaurant, bars, nightclubs, we see a lot of negligent security claims at those as well, that those businesses do not have the presumption against liability with compliance. They do, as I mentioned earlier, have the benefit of both the reduced comparative, so they have the modified comparative applies to those businesses, as well as the ability to apportion fault to the intentional tortfeasors. Those would also apply to the hospitality industry. But as far as these listed, factors that we've been talking about for a little while now, those do not create a presumption. But as Randy can tell you as well, those are the same things we look at when we're defending, these negligent security claims at a hotel or a bar or nightclub. The same things we're doing is we're going out there, we're looking at the security at a hotel, we're looking at the CPTED design of the property, we're looking at natural boundaries, fencing, landscaping. Do they have security guards? Is the lighting sufficient? So even though there's not that presumption, the factors that go into the analysis of negligence claims is essentially the same. And the more that you can comply with hospitality, the better a position you'll be in as well. You're just not going to have the benefit of that presumption, unfortunately.
Okay, that makes sense then.
I'd like to sort of pitch in on this,
Yeah.
because this law is so poorly written and because there is no resource to call in the Florida Attorney General's office to ask, hey, I'm running this type of building, do I need to do this? And because the AG's office is going to say, not my job, I don't know, don't care, it was a legislative rule that was passed and we want nothing to do with it. So, but how do you respond to multifamily housing when you have a long-term care health facility? What about a hospice? What about a nursing home? What about hotels? There's not your regular hotels, but the long-term hotels that you rent for 4 or 5 months or a year that Marriott does and Hilton does that aren't really hotels, but you rent on a monthly basis. Well, that's multifamily housing, and there's been no direction. The AG's office is basically, we're clueless, and we don't know how to answer you because we have no one to ask. No one can hear us scream in space. It's very annoying because these are all great questions, and it's more than just a condominium building. Or what happens if you have an Airbnb high rise? Okay, is that, or it's short-term rentals, but yeah, it's multifamily, and maybe there's owners that bought it that are now leasing it out for a week for people wanting to come to South Florida, Disney World. So
Yeah.
I think it does apply to other buildings, and of course, I've been asking the powers that be, and basically I'm told to go away, you annoying little man. You're bothering me.
All right, I hear you, man. Well, next slide died and it came back. For what's it? HB 1423 would have stripped your HB 837 liability protection if just 2 violent crimes were reported in 24 months, so 2 years, regardless of your security measures. And what that meant, cameras alone aren't enough. You have cameras, but it'd be best having that proof that you acted and more of a proactive versus retroactive approach, is needed. Hardware alone isn't enough nowadays. And that's really where Clouda kind of chimes in. So for us, we are AI video surveillance company, giving you that proactive approach with remote gardening and AI software to help protect your community during the times needed. We've been around for quite some time, and 99% client retention rate year after year, 98% client deterrence rate for the past 3 years, 100% client satisfaction rate. We're actually offering a really sweet promotion right now where it's 50% off of all cameras until September 1st. So property owners, managers out there right now, if you are in the Florida area, you're trying to get compliant, maybe you have cameras down, maybe they need to replace. We're in budget season right now. We are offering 50% on cameras up until September 1st. So if you need quotes going into budget season for that 2027 budget, if you have a little bit of CapEx that you want to spare now to really make sure that you are compliant and protected going in with these shaky laws, reach out, let us know. We got you covered, myself, as well as everyone from our amazing team. We'd be happy to provide you a demo, give you more additional information, and again, quotes to satisfy you for the new budget season. I know that's pretty much all of us. Let's kind of go and see if we got some Q&As. I know there's some Q&As that
JT,
popped up on the
I
way.
want to
Yes,
jump
sir.
in if I can on this the slide before last about if this new law says if you have 2 crimes over 2 years, that's 1 crime a year, it basically removes your protection, your liability protection. What
Yeah.
the biggest word in that particular law that's if you have 2 reported crimes, well, I experience a lot of times that the property managers are not getting the police reports from the police agencies, so they're not even aware that on Saturday night at 4 o'clock in the morning there was a domestic shooting in the parking lot or a purse snatching, because it's being called right into the real-time crime center and police officer comes to that report. So unless these property management companies have a very strong relationship with their local community policing resource person, where they know if something has happened on that real estate, they get the property manager gets a copy of the report, because if it's the same unit, apartment unit or condo unit that's having problems, they got a meth lab in their apartment, property management needs to know about it, so they get them kicked out and get them bounced from their lease. So the lack of, and this is again sort of a legal issue, ignorance is not any defense in the law. So if you're having criminal incidents that result in a police report on your real estate, the property management has to know, the HOA has to know, whether it's an outside party, whether it's a resident, whether it's the malevolent children, whatever it is, the management and ownership has to know, so that they respond quickly. Again, having a paper trail. We know, we did, we conquered. This is what we've done about it. Amanda, what's your thoughts about
I was
property
going to say,
management
Amanda,
team,
anything to add to that?
knowing what's going on?
Yeah, absolutely. And I mean, they did try when they tried to pass that bill, they did try to limit it ultimately to a certain number of crimes. So initially they just said if you have 2 crimes, then it kind of turned into violent crimes, and they enumerated, rape, assault, murder, things like that. But yeah, so I think that they were heading down that road to try and limit it a little bit more with the hope that it was going to pass. Thankfully, it died. But I agree that it's important, because there are a lot of times that a property just wouldn't know about an incident. I mean, obviously, sometimes you have, off-duty officers residing at your property. That's very common. Sometimes you have, maintenance or on-site leasing staff or management staff residing on the property. So they might be aware if there is police activity on site. But if you have a big property, you might not know that either. So I agree that it's important to have that relationship, because even though practically speaking, as a property manager, you might not have any reason to know about those things. But again, when a claim is filed or something happens, that claimant attorney, that plaintiff expert, they're looking at this as hindsight. They're looking at it as hindsight. You should have known. Why didn't you know? And it's a lot harder to try and explain why you didn't know when you're looking at it in hindsight. Everyone says, everyone wants to Monday morning quarterback, what happened. And unfortunately, you just it's not practical to always do that. But if you don't have that information and you aren't aware and you aren't involved with law enforcement, you don't have that information in real time, it looks worse trying to explain that, down the road when you are faced with this issue. So I agree that that is one of the biggest obstacles to compliance with that bill. And hopefully it doesn't resurface, but I have a feeling that you're right, it's going to. And hopefully, when it does, we'll be ready to push back once again.
Yeah, it's like that good old Terminator movie, where he's going down in the lava with that thumb. I'll be back. So that's what that reminds me of. Now, a question popped up in the chat, and they asked, what the motive behind 1423 was. What do you think the motive was? And that's really to both of you guys.
Randy, do you have any
Well,
thoughts on this?
I'll add a point of sarcasm here, and I'll let you jump in. This is clearly a plaintiff's attorney's perspective of how can I pierce the corporate veil with if I have two crimes on the property. Well, we're dealing with properties that's not just a quadruplex, but it's a 400 to 600 unit property. Are you going to have a crime a year? Yeah. Now you're hoping that it's not a murder a year, but again, the ability of the property management and ownership having records that show we have a relationship with the police. Yes, we're aware this particular tenant is a problem child, and this is the action steps we're doing for their removal and or correction of the gate, making sure the gate arms are fixed, making sure that we have roving patrol, which is sort of where cloud structure comes in, providing a virtual roving patrol service. Mm-hmm. So whatever it is, you have to be able to be aware of the fact that stuff is going to happen on my property, and if it hasn't, then it's just for the grace of God, and you've been are lucky. But my calls every week from attorneys are just enormous. I mean, I just turn down most of the calls because it's just too much. So mm-hmm. the number of calls coming in for plaintiff and defense cases has not decreased at all. But now that this law's been in effect for 3 years, now there's a virtual line in the sand of what can I do to show competency, and versus just assuming the risk.
Yeah, and I think as far as why this bill surfaced in the first place and why it's probably going to resurface is we do have that one personal injury firm, the big one that everybody knows about and likes to complain about. They're right here in Orlando, and like it or not, they have a lot of power in Florida over litigation, and they are not only powerful, but they are trendsetters. And unfortunately, when they start doing something, other firms follow suit. I mean, I can't tell you, we've been to trial now. We've had trials with other law firms, and they've basically just completely stolen their jury selection, their voir dire right out of the playbook. I mean, they're literally, the other plaintiffs' firms are just doing exactly what they're doing. And so when you have these powerful firms based here in Florida that have the ability to go and lobby and push back against these tort forms, they're going to continue to do it. And that's really the only way to describe it is, unfortunately, there's just, they want their litigation. They understand that the, verdicts are still the way they are in Florida, and they still do have a lot of power here. And as long as, that continues and until the pendulum swings back the other way, we're going to continue to see challenges to these tort reform laws.
Yes. Well, definitely. I mean, I appreciate you guys so much. I know we're coming up here short on time. Mario's going to be launching a quick poll within the chat. So there's 2 questions there. If all the attendees, please knock those out for us. And then definitely join us next time. We got a pretty big one, which is becoming, a pretty big deal across the nation. Little residents, big liability. You see the e-scooters, you see the e-bikes all around now. They're all over the news, and rules and regulations, fair housing, all that good stuff in conjunction to that. So that's going to be our next free webinar. Please, please, please register, jump on that now. Again, it's free. It's going to be hosted by our Gen Free over here with Clouda, and it should be one that you guys would definitely want to take advantage of. Now, we got a few questions in here. Let me see if I could fire some off. For Amanda, if a resident is assaulted in a common area and the property has Safeguard Harbor certification, can the owner still be held liable at all?
But Potentially, yes. However, if you have those measures in place, you have the CPTED certification or the assessment done, you have your compliance with the remaining factors there, then once the suit is filed, then we have that presumption. And obviously, if there's a foreseeability issue, that's also potential grounds for summary judgment. So, I mean, could they? Yes. The likelihood goes significantly down, though, if the compliance is met. So that's what it's there for, is to create that presumption, to give us the summary judgment argument, and to get you out early so that there isn't the potential for liability. Because once you get to a jury, anything's possible. And that's the reason why I say possibly, is because juries are going to do crazy things. So the more compliance we have up front, and the more we can get it out of the hands of the jury and ruled on by the court, the better off you'll be, and the earlier the claim will resolve or come to an end completely. So that's certainly the goal.
All right. And then last one, Randy, my friend, looks like question came in. We have older buildings. They were constructed before modern security standards. Is CPTED certification even realistic for properties like that? Or are we just, kind of setting ourselves up for disaster?
I would submit for your consideration that the Americans with Disabilities Act is a perfect parallel universe of what we're experiencing now with this security and CPTED law in the state of Florida. The ADA said that regardless of when your property was built, you have to make it accessible within, as reasonably as possible, unless you have structural infeasibilities. And complaining was pretending you had a choice. It's a federal law and enforced accordingly. Here we have a state law that says you should be conducting these security assessments and making the corrections for substantial implementation. And if you don't, then you have no leg to stand on when you're in front of the judge and saying, well, this is the first murder we've had. Well, that doesn't count. So if you have an older building, I would say that 75 to 80% of the recommendations I make from a CPTED perspective are low-hanging fruit and are maintenance fixes: painting, additional lighting, making sure the gates close, making sure that the doors lock properly, making sure that the hardware is correct. So getting a good deadbolt lock and using 3-inch wood screws instead of a 1/4-inch screw that comes with a quick set lock set is pennies on the dollar. And the only items that are really the big ticket infrastructure items that are tough to absorb is typically the lighting in the parking lot. On the other hand, when I go to a property that the lighting is awful in the parking lot, and I recommend, we need to have all new lighting here, so they have to invest a couple $100,000 in LED lighting, but with the energy savings, your return on investment is 2.5 years. So if you amortize that out and you know that you're going to be getting savings of tens of thousands of dollars every year within 2 to 3 years, you have money, you're in the black, you have money that's coming back to you because you're not having to do extra maintenance and the extra utility bills and the electricity, etc. So yes, older buildings should be done, and they can be done. And if it's structurally infeasible, then that's it. But there's nothing infeasible about lighting, fencing, good landscaping, good lighting, good signage, and good tenant screening.
Well, thank you. Thank you for that. Yes, that makes sense. I mean, that brings us right at to time. I want to thank you guys both so much. Amanda, Randy, thank you so much. You guys are a wealth of knowledge, and with you guys' background experience, truly made this webinar. So thank you so much. I have you guys' email addresses posted up here on this slide. Is this the best way for people to reach out to you? Will it be via email, LinkedIn?
For me, email or a bat signal works fine.
Yes, email is fine. LinkedIn is also fine, but this is the correct email address. And I see you also put the website links in the chat as well. So either way, you can find us there.
Great. Well, both, thank you so much. Everyone, thank you so much for taking the time out of your day to join us. Again, my email address is there as well. If you're looking to receive quotes, looking to stay compliant, don't hesitate to reach out by clicking onto the website, cloudedstructure.com. Until next time, you guys have a great rest of the day, and we appreciate you joining. Bye now.
Thank you. Thank you for having us. Bye.